Good afternoon, everyone. Welcome to the remote Klimt residence. E-signing is very topical. This webinar could not have been timelier. Yesterday, the Federal Treasurer made an emergency declaration which, amongst other things, will remove uncertainty and facilitate the execution of company documents by company officers electronically during the COVID-19 pandemic. We'll be discussing this further today. We at Clayton Utz have had a group working through issues on this over the course of the last year. We've expedited progress and changed focus slightly in light of COVID-19 and social isolation. The purpose of this session is to fill you in on some of the legal issues at a fairly high level and provide some best practice principles on these issues. Also, I stress what we're about to say is up to date as of today. We in fact checked it about an hour ago, so I hope things haven't moved in the last hour. But as you'll see, things are moving quickly in terms of regulations being made to facilitate remote working in response to social isolation. And finally, by way of introduction, thanks to Laura Frank, Heather McFarlane and Phil Dang for assisting with the technical side of this webinar. If it goes seamlessly, it will be all due to them. If there are problems, it will be solely due to my technical ineptitude. Today, we'll be looking at four things. 1, electronic signatures in Australia. 2, the legal risks and uncertainties. 3, we'll be going through a potpourri and a selection of solutions. And 4, we'll be updating you on emergency laws and regulations. Now, I'm going to start by talking about electronic signatures in Australia. It is generally acceptable for most contracts that do not take the form of a deed to be executed using electronic signatures in Australia. If there's no Australian statutory requirement for a contract to be in writing or signed, there's nothing to prevent a party from using an appropriate electronic method to sign it. That said, there are evidentiary reasons why a written and signed contract is best practice. Where there is a specific Australian legal requirement for a contract to be in writing or signed, a party would generally be able to rely on the Electronic Transactions Acts to satisfy writing and signature requirements. The Electronic Transactions Acts exist at a federal, state and territory level, and while they are all broadly similar, there are significant differences in relation to the types of documents and legislation that are excluded from their enabling provision. Paul Cullen will discuss this in more detail in a moment. In December 2018, New South Wales became the first Australian jurisdiction to allow deeds to exist in and be executed in electronic form. While this is a significant reform, there are some doubts the changes extend to companies, and while it is possible for a person to witness a document electronically, there is a higher degree of risk that the minimum requirements for attesting a document will not be met, such as the requirement for the witness to be physically present. Where the ETA regime, or in the case of New South Wales, the Conveyancing Act does not apply, the common law applies. Courts have traditionally given a broad meaning to the word signed, but the overriding message from the case law is the fact that there must be some kind of personal authentication of the individual signing in order for the electronic signature to be valid. In the fairly recent DY Logistics case, Justice Croft considered the exclusion of the Corporations Act from the ETA and considered that if the function of a signature is satisfied under the common law, it is a signature for the purposes of the Corporations Act. What this means in practice is that if a person's digital signature is used, there would be problems if there is insufficient evidence of the authorization for it to be applied. So therefore, it's important in using digital signatures that sufficient evidence of authorization is obtained. That will generally be done through the commercial electronic document execution services. Many documents may be validly signed and created electronically under the ETA regime. I stress the Electronic Transactions Acts do not displace the common law. Under the Electronic Transaction Act regime, if a law requires a person's signature, there are broadly 3 requirements for an electronic signature to be valid, and they are identification, reliability, and consent. But I stress the ETA, the Electronic Transactions Act, only applies if there's a requirement in law for a signature. Looking at each of these specific requirements in more details, first, the method of execution must be able to identify the person signing and confirm that they intend to be bound by the information communicated. This may include, for example, an image of a handwritten signature embedded in a Word document containing text that the individual is taken to have signed. Secondly, the method used to sign must be as reliable as appropriate in light of all the circumstances. For example, it may be sufficiently reliable that the requirement is required to enter a password before opening a document and inserting his or her electronic signature. These measures can fulfill the functions of identification and confirmation of intention to be bound. Alternatively, this second requirement can be satisfied by proving that the method used actually identified the person and indicated intention by that person to be bound. Thirdly, the counterparty to the document must agree to the document being signed electronically. In general, this consent should be obtained before the parties enter into the relevant document. Sophisticated electronic signature platforms such as Adobe Sign and DocuSign have solutions for these requirements. From a practical perspective, a person signing electronically should always directly inform and obtain the consent of the relevant counterparty. Now, just one final note on this issue. Although electronic signature and digital signature are widely used terms, they can mean different things and they're not terms of art. For example, they can include a name keyed in by an individual in an email or online application form or other document, with or without information confirming the signatory's identity, an image of a handwritten signature embedded in a Word document containing text that the individual is taken to have signed, as I mentioned earlier, an individual applying a stylus, such as this, or a digital pen or finger on the trackpad of a laptop to draw a signature on the computer screen, which is captured electronically in digitized form and linked to a contract, again, with or without information confirming the individual's identity. A secret code or personal identification number, which is a shared secret by which the signatory is able to be identified to the recipient of the electronic message communication containing the signature. Digital signature technology based on a code or encryption system, which enables an individual electronically to sign an electronic document and a person who is relying on that signature to use software to verify who signed the document and to verify that the document has not been altered since it was signed. And finally, a biometric identifier, such as a thumbprint or retinal scan, by which the recipient is able to verify that the purported sender of the document is in fact the sender. And now I'll hand over to my colleague, Paul Cullen.
Thanks, Stephen, and good afternoon, everyone. I hope you're all keeping well and surviving during these most unusual times. My name is Paul Cullen. I'm a Senior Associate in the Banking and Financial Services Group at Clayton Utz. As Stephen mentioned, the ETA regime does not displace the common law. So where the ETAs do not apply, the common law will apply instead. This has been confirmed in a series of recent high-profile cases involving Bendigo and Adelaide Bank. For example, in DY Logistics case, Justice Croft said that the ordinary meaning of the word signed is elucidated by the common law. He then went on to say that a person may sign a document by stamping their name, by typewriting, or by printing. But what is always required for signing to be effective is that some sort of personal authentication of the individual signing takes place. In a separate decision, which also involved Bendigo and Adelaide Bank, Justice Croft said there is no reason why the assumptions in the Corporations Act should be confined to signatures made with a pen. So in other words, if the function of a signature is satisfied under the common law, it is a signature for the purposes of the Corporations Act. There are, however, additional risks when the company is signing and they have more than one company officer or more than one director who needs to sign a document, because this raises the vexed question of split execution, where two company officers sign on different counterparts. Now, Stephen Klimt will be addressing this a bit later on in the presentation, and he will also talk about the impact of the corporation's determination made by the Federal Treasurer yesterday. So turning to the next part of the presentation, we will be talking about some legal risks and uncertainties. So the first part of the presentation, we've been talking about when an e-signature will be valid under Australian law, but as always, there are always some risks and uncertainties, and so this part of the presentation, and just turning to the next slide, we will look at three areas where you might find difficulty, and this should be approached with caution. So we're looking at deeds, documents that are required to be witnessed, and perhaps to a lesser extent, documents that are excluded from the ETA regime. Out of these three categories, arguably the document that causes the most difficulty are deeds. And this is because there are additional formalities that apply under both the common law and statute. Given these inherent risks, you might be asking, why do lawyers use a deed instead of an agreement? And to be honest, it is a good question, because often an agreement will be suitable in most circumstances. However, deeds will be used in at least three situations. Firstly, where a particular statute requires a document to take a form of a deed. So an example of that is under the New South Wales Conveyancing Act, certain assurances of land must take the form of a deed. Secondly, to import consideration, one of the legal requirements for a proper formation of a contract. Deeds automatically import consideration. Thirdly, to take advantage of the extended limitation period that applies to specialty instruments, which includes deeds. In every Australian jurisdiction, the limitation period for deeds is at least double that of other contracts. So not an insignificant consideration to think about when deciding to use a deed or an agreement. Most formal requirements have over time been altered by legislation, but one of the remaining formalities that brings uncertainty in the context of e-signatures is the common law paper rule, which is still cited in Australian case law today. By way of background, the paper rule requires a deed to be written on paper, parchment, or vellum. These days, parchment and vellum are probably only ever used by wedding planners and for making greeting cards. So in this day and age, it is difficult to understand why these materials are preferred over a deed executed in electronic form. However, in most Australian jurisdictions, the paper rule has not been expressly modified by statute. The one exception to this is a deed executed under the laws of New South Wales. However, we have some doubts that this extends to corporations because of the way the new provisions are drafted in the Conveyancing Act. All that said, recent comments by Justice Stanley in Pickard's case, which Stephen spoke about earlier, indicate that Section 127 of the Corporations Act actually modifies the paper rule for companies signing under that section. I think lawyers and legal experts got quite excited when they read that in Justice Stanley's decision. However, the case cited by Justice Stanley in support of his comments does not directly discuss the paper rule. And then we had a further decision in the New South Wales Supreme Court where Justice McCallum actually made comments to the contrary and appeared to reaffirm without deciding that the paper rule in relation to deeds executed by companies is still a common law requirement. So until these issues are properly resolved by statute or a higher court, we think it is prudent to continue to require deeds to be signed on paper. Stephen will have more to say about this when he discusses the impact of the new corporations determination. The second category of documents that can cause problems are documents required to be witnessed. There is limited authority as to what is required for effective witnessing by electronic means. So, for example, it's harder to satisfy the minimum requirements for attesting to a document, and that includes the requirement that the witness be physically present at the time of signing. As you probably know, new legislation is being made in around Australia that will address this issue on a temporary basis. And in New South Wales, you may have seen that video technology is now able to be used for witnessing documents. However, these laws will have only temporary application, and Stephen will cover this in more detail in a moment. The last category of documents that should be approached with caution are documents that are expressly excluded from the ETA regime. Whilst exclusion from the ETAs does not necessarily prevent a document from being signed electronically, there may be other factors and practical issues which require documents to be executed with a pen. In general, the ETAs in each jurisdiction are broadly similar, but there are significant variations among the jurisdictions in relation to the types of documents that are excluded from the enabling provisions. So turning to the next slide, we've put together a table containing some of the documents that are excluded from the ETA regime. The ETA regime also excludes some statutes. At the top of the table, you can see that any requirement under the Corporations Act is excluded. I'll come back to that in a moment. But as for the other documents, in most cases, these documents require or are related to documents that require registration, stamping, or some form of physical lodgement with a court or other government registry. So it's always prudent to check with those particular bodies to see whether they will accept e-signatures for documents lodged with them. This is not an exhaustive list, so where there is doubt should always refer to the ETA regime. As I mentioned, the Corporations Act is excluded from the Commonwealth ETA, so that excludes documents executed in accordance with Section 127 of the Corporations Act. However, the Corporations Determination effectively reverses this for Section 127 execution on a temporary basis. So, turning to the next slide. Okay, so this is the last slide of this particular section. This slide summarises some best practice principles and suggestions that we've put together, and just sort of summarises some of the things we've been talking about. So the first one we've suggested is to use deed form only when legally required, and this is due to the inherent risks with executing documents electronically that we've already discussed. As I mentioned earlier, often an agreement will be sufficient. Obtain the express written consent of each party to the use of e-signatures. This is not only best practice, but is required if a party is seeking to rely on the ETA regime. Use a sophisticated e-signature platform such as DocuSign or Adobe Sign. These platforms will generally have solutions to satisfy the three requirements under the ETAs, as discussed by Stephen earlier. Those are identification, reliability, and consent. Check the relevant ETA and their regulations to find out whether they will validate a document being signed electronically. In addition, we're going to discuss some of the emergency laws and regulations a bit later on, but those emergency laws and regulations should be checked as well at a Commonwealth, state and territory level. If a document is required to be registered, filed, stamped or to satisfy some other formality, check with the relevant regulatory body that they will accept e-signatures. It's always prudent to do that. Personal authentication is the last principle I wanted to mention today. We've already mentioned that a few times already. It is critical that an e-signature is only ever attached to a document with the express approval of the person whose signature it is. Recent case law would suggest that the easiest way to mitigate this risk is to require the signer to affix their own signature to a document rather than someone else on their behalf. E-signature platforms have methods to demonstrate this. For example, the recipient of the document may be required to enter a password before they can open it. I'll now hand back to Stephen.
Thanks, Paul. I'd just like to mention that there is a Q&A function on this webinar, and if you have any questions, I think you're able to post them through the Q&A function, and they'll then presumably appear for everyone to see, and we'll attempt to answer the questions either through the course of the presentation, or we've allowed time at the end of the presentation for questions. So please feel free to use the Q&A function and ask your questions. So I'm going to talk about potential solutions. As a result of the COVID-19 pandemic, we've put together a number of suggested signing options for companies with more than one company officer. This is due to the issue that Paul's mentioned earlier, commonly referred to as Litt Execution, which obviously has been exacerbated by the Australian government's social distancing and isolation requirements. Litt Execution occurs when two company officers execute a document on behalf of a company under either subsection 1271(a) or 127(b) of the Corporations Act on different counterparts, instead of both signing the same document. Courts and practitioners alike have been split on whether this constitutes valid execution for the purposes of section 127. As Paul pointed out earlier, there's real doubt in the case law as to whether there can be a valid section 127 execution by two company officers on different physical documents. However, I'm pleased to say that this doubt has now been removed, at least on a temporary basis, by the legislative instrument made by the Federal Treasurer yesterday. The next two slides set out 4 devices you may wish to consider to help manage the risks associated with split execution during the COVID pandemic. The first option is simple and straightforward. It involves the first officer signing a hard copy document with a wet ink signature and either sending that document via courier to a second officer who countersigns the same document, or the second officer signing a separate hard copy counterpart of the document in wet ink in reliance upon the Commonwealth legislative instrument. Section 127 of the Corporations Act does not require that the two signatories sign the document in each other's presence. This remains a safe method of executing documents, as it allows counterparties to rely on the statutory assumptions in sections 128 and 129 of the Corporations Act, and it therefore can be used for all types of documents. It would be prudent if the multiple counterparts option for this method is adopted to ensure that the agreement itself contains a clause that permits a single party to execute a document using multiple counterparts. The second option also involves execution under section 127 of the Corporations Act. However, instead of signing on paper, the two officers execute the document electronically. This can be done via an electronic document platform such as Adobe Sign or DocuSign, or now, at least during the COVID-19 pandemic, on separate electronic counterparts, such as separate PDFs emailed to each company officer. Most electronic execution platforms have processes which purport to cause both signatories to concurrently sign the same electronic document, or simultaneously apply their signatures to a single electronic document with their authorization, together with a mechanism to record that fact. However, recent judicial analysis has cast doubt as to whether this could ever be the case when two electronic signatures are required to be affixed to a document. Justice Stanley in Pickard's case said, given that section 1271 contemplates a document being executed by two officers signing it, there is good reason to consider there must be a single static document rather than a situation where two electronic signatures are sequentially applied to an electronic document. In our view, provided the signatures are added to the same electronic documents, as most electronic document platforms purport to do, it will be validly executed. Note that Justice Stanley only framed his comments in terms that there is good reason to consider, and did not in fact provide any reasoning for his approach. However, the judgment reflects some residual risk with this approach. This residual risk and doubt has now been alleviated, which is good news, at least on a temporary basis, by the Commonwealth legislative instrument, which in fact expressly permits the execution under section 127 by two company officers on separate electronic documents. This method that may be appropriate for agreements, but in our view should not be used for deeds, except in New South Wales, where there is reliance upon the emergency regulation. For the reasons outlined by Paul, in New South Wales, the effect of the amendments of last year to the Conveyancing Act is that the paper rule for deeds has been abrogated. Hence, conceptually, if a section 127 execution can be effected on an agreement electronically using the same electronic document, there's no reason why it cannot apply to a deed which can be in an electronic form. We do not advise relying upon the Commonwealth legislative instrument to execute deeds electronically unless it cannot be avoided, and I'll outline the reasons for this later in the webinar. The third option involves using an authorised agent signing a document on behalf of the company under section 126 of the Corporations Act. Under that section, a company can execute a contract using a common seal, without using a common seal, so that's without using a common seal, if the power to do so is exercised by an individual acting with the company's express or implied authority and on behalf of the company. This method has the advantage that one person can be appointed as the company's authorised agent to sign contracts on behalf of the company, thus circumventing the potential risk of split execution. If a party proposes to accept execution by an agent on behalf of a company, it should satisfy itself that the agent has been validly authorised to execute the document, and keep records to prove that the agent was so authorised. Additionally, the execution clause should make it clear that the person or persons are executing on behalf of the company, because execution in this manner is not execution by the company. There's case law to the effect that an incorrect execution clause along these lines in fact means there's no valid agreement. A board resolution alone is not sufficient to confer authority on an agent to execute a deed on behalf of a company. This is because of the common law principle that authority to execute a deed must also be by deed. This process could be used for executing documents electronically via a sophisticated electronic document platform with no greater risk than signing documents with wet ink signatures on paper. It can also be used for executing paper documents. This method may be appropriate for agreements, but should not be used electronically for deeds other than in New South Wales. Bear in mind the witnessing rules in all jurisdictions apart from Victoria if this method is used for the paper execution of a deed. Now, the final method we want to discuss today is known as modified split execution. This has the most risk and in our view should only be used as a last resort. It involves an officer of the company signing a document with a wet ink signature and then faxing or emailing a PDF copy of it to a second officer at a different location with the intention the signature on the printout made by the recipient's second officer is to be treated as their signature. The second officer then prints and also wet ink signs that faxed or PDF copy. Some people have asserted that this method of execution satisfies the requirements of section 127, provided that the first officer personally intended the signature on the printout to be treated as their signature. This essentially relies on the premise that the printed fax or PDF is like a stamp. So the printing of the fax or PDF by the second officer is no different to the first officer authorising the second officer to affix a stamp of their signature to the document. However, we have real doubts that this gets around the issue because the doctors are not affixing their signatures to the same printout. The first officer's signature was already affixed to a document. It is difficult to see how printing the complete document containing a signature constitutes the signing of that document by the first officer. Any company proposing to use this method should, in our view, be properly apprised of these risks. The making of the Commonwealth legislative instrument, however, will probably render this method irrelevant for the duration of the COVID pandemic because it's now clear that agreements can be executed using counterparts under section 127. Emergency laws and regulations are being made to assist parties with remote witnessing and attestation of documents. However, where a document is required to be witnessed, you should ensure compliance with existing signing and execution requirements until such regulations are made. This slide sets out some strategies that can be used to deal with witnessing documents during the COVID-19 pandemic. For agreements, witnessing of an individual's signature is prudent but not essential unless it is specifically required under law. However, witnessing or some form of authentication is recommended for evidentiary purposes. Where a document can't be witnessed in the usual way, consider these options. First, use an electronic document platform such as Adobe Sign or DocuSign. In most cases, signers will be self-isolating with other people, such as family members. Therefore, a family member can act as a witness. He or she will be physically capable of satisfying the minimum requirement for attestation, such as being physically present for signing. In addition, or as an alternative, parties can put in place measures to authenticate the signer, which in effect will serve the same purpose as witnessing. In other words, the record of the procedures used to authenticate the signatory can serve a similar purpose as a witnessing attesting that a person physically signed a document. However, Be conscious that it is unlikely that the use of the witnessing feature on an electronic signing platform that does not specifically require physical presence will satisfy witnessing requirements. Moreover, be conscious that electronic technology can ironically potentially be used to disprove that persons were physically present with one another, notwithstanding they may have asserted that they were. Secondly, sign and witness agreements via audio-visual link. This is now permitted in New South Wales with recent changes to the electronic transactions regulation, although it is more risky in other jurisdictions that have not enacted this reform. I'm going to discuss this in more detail when we have a look at some of the new reforms that have been made around Australia as a result of the COVID-19 crisis. For deeds, witnessing of an individual's signature is required in every Australian jurisdiction except Victoria. Where a deed cannot be witnessed in the usual way, consider these options. First, consider converting documents styled as deeds to documents styled as agreements wherever possible. For example, there may be a document that can be converted from a deed to an agreement simply by providing for nominal consideration, such as $10. If a document can take effect as an agreement instead of a deed, use one of the witnessing methods I mentioned for witnessing agreements, if witnessing is required. Secondly, where appropriate, consider making Victorian or New South Wales law the proper law, the governing law of the deed, given witnessing of deeds is not required in Victoria and New South Wales allows witnessing of deeds to be done via an audio-visual link. I'll now talk specifically about the emergency laws and regulations. Emergency legislation has been enacted by the Commonwealth and by some states and territories to create regulation and declaration making powers. The next slide, please. Which could be used to provide for electronic signing and the modification of requirements such as witnessing. However, the new laws are intended only to have application while social distancing and isolation measures are in place. In broad terms, the laws either permit regulations or declarations to be made in relation to signature, witnessing and attestation requirements. To date, New South Wales and the Commonwealth have passed regulations or declarations pursuant to these powers. And the slide sets out the current state of play in all the states and territories to date. Now, the Coronavirus Economic Response Package Omnibus Act 2020, great name for an act, inserted section 1362 capital A into the Corporations Act. This empowers the Treasurer by legislative instrument to modify the operation of provisions of the Corporations Act if the Treasurer is satisfied relevantly that the modification is necessary or appropriate in order to facilitate continuation of business in circumstances related to COVID-19 or to mitigate the impact of COVID-19. The maximum duration of any such legislative instrument is 6 months. The Treasurer yesterday made the corporations, open brackets, very complicated, coronavirus economic response, close brackets, determination, open brackets, number 1, close brackets, 2020. Again, very technical formal language. The determination applies until 6 November 2020. It permits Section 127 executions by a company to be signed on separate counterparts that can be either in paper, the determination actually uses the expression in a physical form, or the counterparts can be in an electronic form. I make the following points about the determination. First, it removes any doubt, to the extent it existed, that there can be electronic execution under Section 127, at least on a temporary basis. Secondly, it clearly removes the doubt expressed in Pickard's case, at least on a temporary basis, as to whether the application of two electronic signatures can ever be applied to the same electronic document. It does this by expressly providing that Section 127 executions can be made by a company on separate documents, whether they are electronic or paper. Thirdly, as I indicated earlier, we think it advisable if split execution under Section 127 in accordance with the determination is to take place, for there to be a clause in the agreement enabling execution by a single party in multiple counterparts. Fourthly, the determination adopts the first two limbs of the Electronic Transaction Act requirements in relation to electronic signatures, but does not adopt the third limb. This means that in order to rely upon the determination, care must be taken to ensure that the methods used for electronic signing identifies the person who's signing, indicates their intention to be bound, and is as reliable as appropriate for the circumstances. However, contrary to the position under the Electronic Transactions Act, consent of the other party to a transaction will not strictly be required. Although, as Paul set out earlier, we think that's good practice to do so anyway. Fifthly, the determination can only be relied upon if the document in full is signed. It will not be sufficient merely to sign a counterpart of the execution page. Sixthly, it is not clear to us whether the determination removes the paper, parchment and vellum rule for deeds. Our initial view is that there must be significant doubt as to whether it does this. Ultimately, it seems to us that it comes down to the issue of whether Section 127 of the Corporations Act is a statutory provision which regulates the making of deeds in their entirety. If it is, then the determination would remove the paper rule. The converse, of course, would be true if that were not the case. The current state of jurisprudence on this issue is limited, as Paul pointed out, to two opposite and unreasoned statements made by single state Supreme Court judges. It's also significant that the explanatory statement makes no mention, the explanatory statement to the declaration makes no mention of the electronic execution of deeds. For that reason, we would suggest that the determination should only be safely used to execute deeds under Section 127 using multiple paper counterparts. Only as a last resort do we think it should be used for electronic execution of deeds. I add that the determination will also allow companies to convene annual general meetings and other meetings prescribed under the Corporations Act entirely online rather than face-to-face, again, on a temporary basis. So finally, let's look at the New South Wales changes in more detail. The key initiative of the New South Wales Parliament was to allow the witnessing of signatures via audio-visual link during the COVID-19 pandemic. Audio-visual link is defined as technology that enables continuous and contemporaneous audio and visual communication between persons at different places, including video technology. From a practical perspective, this would include video technology such as Skype, FaceTime and Zoom. To be effective, the witness must comply with the following requirements. First, observe the act of signing in real time. Now, this may in fact prove easier said than done. The New South Wales Law Society guidance suggests that camera angles are important for this requirement to be signed, because you need to be able to not merely see a hand signing a document, but also see that the hand belongs to the particular person that you've identified, and in addition, that the person is actually signing a particular document. Secondly, confirm that the signature was witnessed by the witness signing the document that the signer signed or a copy of that document. Third, the witness needs to be reasonably satisfied that the document the witness signs is the same document or a copy of the document signed by the signatory. Again, this might be easier said than done. The New South Wales Law Society suggests that for documents being signed in counterpart, one way for a witness to satisfy themselves might be to have the document read aloud by the signatory so that witnesses can check that the counterpart is identical. Another way might be to ask the signatory to hold it close to the camera and conduct a page turn comparison. All very tricky. And then finally, the witness must endorse the document or the copy of the document with a statement specifying the method used to witness the signature of the signatory and that the document it witnessed was in accordance with the regulation. The changes apply to a broad range of documents, including wills, powers of attorney, deeds, affidavits, and statutory declarations. I have, in fact, two personal experiences of witnessing issues under COVID-19 already. First, I had to witness probate documents for a friend of mine before the remote witnessing regulations came into effect. We did it at a distance, wearing masks and gloves in my backyard. Very inconvenient. And secondly, I have actually taken advantage of the video witnessing provisions by witnessing a statutory declaration my son had to sign. We did it using FaceTime. A couple of points to note. He did it by typing his signature onto the document because he didn't have a stylus for his laptop and didn't have a digital signature, and I had to watch that. I then had his girlfriend video his execution so I could see both the keyboard with the document and him typing his signature into the document and his face. He then emailed the document to me and I signed and endorsed the PDF he sent me, which was a copy of the original statutory declaration. So it can be done, but it's not necessarily easy, and perhaps it's not something that you could relevantly trust lay people to do accurately rather than lawyers who think more precisely about these things. One final point I would like to make before going into the Q&A about the current temporary measures is that care needs to be taken by the regulators to use them as the basis of permanent solutions to these issues. The temporary solutions have been prepared on the basis of removing doubts and ensuring remote execution can be facilitated. I've got a nagging concern that if these temporary measures are simply left to lapse, conservative interpretations of the legislation and common law provisions will prevail. This is due to an argument that the conservative interpretations reflect the correct legal position because that is why the temporary solutions were implemented. Accordingly, there's a risk that it might be a one step forward, two steps back circumstance unless proper reform in this area is undertaken. Anyway, with that, we will go to the Q&A, and I will start at the bottom and move up. First question I'll look at is, has there been any Australian court decision as to the validity of DocuSign signatures? I'm not aware of any such court decision. Paul, are you aware of it?
No, there's nothing that we've come across which is sufficiently stress tested those platforms.
Next question is, are there any additional considerations for execution under Section 126 of the Corporations Act? I think that was asked before I went through that part of the presentation, but essentially you need to satisfy yourself that the agent was appropriately authorised, and you should keep a record of that. And secondly, you need to make it clear that the execution is on behalf of the company, not by the company, which is the form of execution clause used and execution used for Section 127 of the Corporations Act. Next question is an email authorising an assistant to apply an electronic signature sufficient to establish personal authentication of the signature? And I note this question had 15 likes, so people are interested in this. The short answer is that, and I'll throw to Paul to see whether he has any comments after that, but the short answer is that provided an email authorises the assistant to execute the specific document, and there's evidence that the person was aware of the specific document, that will be sufficient. I do not think it necessarily would be sufficient if it's a general, I authorise you to execute documents and execute this agreement generally. Paul, do you want to add anything to that?
Yeah, I was just going to say, it's just, if you're going to do that, it's important to really make sure you keep a good audit trail, paper trail of the authorisation, because, you know, there's been case law where, directors have been brought before the court and they can't even remember that they've authorised for their signature to be affixed to a document. So if you're going to rely on an email, just make sure you keep proper and robust audit trails.
Next question is, do both parties need to be on an e-signing platform? Now, I'm assuming this means if one party is e-signing it, does the other party also need to be e-signing it? Do they need to be on the same platform? And the short answer is not necessarily. They can, they cannot. You can use, either party can execute the document in a particular way, but that being said, it may be easier for practical purposes if both parties use the same e-signing platform, because then there's a single record and a single execution copy, and the execution records are all collected in the same place. So there may be practical benefits to it, but there's no requirement for that to be the case. Paul, do you want to add anything?
No, exactly. I mean, I don't know why two parties would use different methods. Technically it's possible, but practically, I think if you're going to use e-signatures, then you should be using the one platform.
Next question is it the same document when software might technically create a new document? We don't think that it is the same document when software creates a new document. So to give a simple example, if I send a PDF to Paul, there will be two separate documents, the PDF that I have sent to him that resides on my server, and a separate version of the PDF that resides on Paul's server. And we think even though the documents are, for all intents and purposes, identical, one is a copy of the other. And the electronic signing platforms attempt to deal with this issue by simply having one electronic copy held in the cloud somewhere, and that one electronic copy is the copy into which the digital signatures are entered, so not on separate documents. Paul, anything to add?
I think and this sort of goes back to almost the last sort of point you made. I think the passing of the corporation's determination and specific reference to DocuSign in the explanatory memorandum indicates that there is some doubt that these platforms create a single document.
And then the final question is, when an agreement is signed by two directors using wet ink signatures and the agreement is then emailed to the other party for execution, do the signatures of the first party to sign become electronic signatures when the document is emailed? No, I think the answer to that is that the first director who signs the document, a paper version of the document using a wet ink signature, that is one counterpart of the document. And then the email document, even if it contains that signature that is sent to the second director, that email document and printed out is still a counterpart of that first document. And when that's signed in wet ink signature by the director, that is the second counterpart. And this, in fact, is an example that is used in the explanatory memorandum to the declaration, and that's what we think the declaration achieves, namely a namely that there are two counterparts and it's not necessarily an electronic signature. Paul, again, do you want to add anything?
No, and it's almost sort of looking at the arguments that are used for the modified split execution, which we've spoken about, and think that there are risks and doubts with relying on that.
And that's why, in fact, we say that modified split execution is probably not particularly relevant nowadays in light of the declaration, because the declaration permits execution under 127 using counterparts, and so you'll just use counterparts. That's not to say it's a method that can't be used, but in fact it's not. I don't think you need to rely upon what we believe is a fairly artificial construct of an argument to say that the printing out of the document constitutes a signature. You can just rely upon the fact that there are counterparts. Anyway, there's one final question, and the final question is, will the slides be distributed? And the short answer is yes, I think we will. The intention is to send a video of this presentation to everyone who either participated or enrolled and couldn't participate in the seminar, together with the PowerPoint of the slides. So with that, we'd like to thank you all for joining us for this webinar. We hope you got something out of it. Please be safe, be socially isolated, and feel free to contact us if you have any further queries. Thank you very much.
Thank you.